All right. Good evening. Good evening, everybody. Hello, hello. I'm a little ahead of my usual 7 p.m., which has turned into 8 p.m. And now we're at 6:30. So sorry about that, but it's just kind of how things go here. Welcome in. Hello. Hello, Mars. We are doing okay today. Duchess, good to see you. Hello. Upgrade 2.0. Hi, hi, hi. Willie B. Hello, Mary. Welcome in, everyone. Yeah, so I did 3 lives yesterday, and then rested my voice a lot. I need to actually start steaming it again, but I have enough. I thought, hopefully, fingers crossed, everybody. I've got enough to get us going tonight to do a little, update on what's going on in the world. There's some crazy stuff going on, so I thought it would be helpful to chat about it a little bit. So, hello, hello, hello. We've got a super big case in front of the U.S. Supreme Court tomorrow. They're going to have oral arguments on the shadow docket. That is this case here, which is the CASA case. And we have an ongoing fight in the U.S. Supreme Court on preliminary injunctions, temporary restraining orders, and what jurisdiction the Supreme Court should have because of questions of final action before. So lots of things going on there. Oh, thank you so much, G-Jack. Appreciate that. Hello, Beth Aroni. Hello, June Marie. Boxer Mom, hello. Yes, we're okay. We're okay. Nothing big has dropped. Yay. But we do have a couple of things going on. So we've got the Supreme Court arguments tomorrow, which should be interesting. I'm going to have to ask Skelikos, if he's going to do a live on that. He is an amazing creator, everyone, on this app. He's also on the Tube, and he just does amazing analysis of U.S. Supreme Court cases and talks about kind of like the background, the justices, and the different kinds of ramifications for the different arguments. So he does great work. So make sure to follow him. Hello, John. Welcome. And let me just see here if I have his name right. I think right now it's Skelikos, and I think on YouTube. Is that right? Is that right? Oh, thank you so much, Professional Spoonie. Okay, Upgrade 2.0, you know, right? Is this right? Is this his name right now? I'm hoping. I apologize. I should do this before I come on. I should just have it on a little card so that everybody knows, because he's just great, and I just will not stop saying go and follow him. Okay, thank you, June Marie. Thank you, Kimber. Appreciate it. Thank you. Yes. So if you are looking for, hello, welcome. If you are looking for Supreme Court discussions, what the cases mean, and an in-depth analysis, he just does great work. Just absolutely amazing work. The other place, of course, if you're looking for resources, would be another creator here, or creators, called the SCOTUS blog. And they have great links where you can find all of their paperwork, the filings for the cases, and explanations. They do a really great work. Is it Bellicose or is it Skelikos? I don't know. My goodness, everyone. I was talking about this great, thank you so much, Just. This really great creator, and she's on right now, and her little thing says On the Hill, but that's not her name. That's not her handle. And she's so great, but, of course I gave out the wrong name. Is it Skel? Okay. Thank you, Sia. Yeah. So it's not, there's no breaking news tonight. Just heads up here, so we should be okay. Hello, Amber. But I do want to make sure to let everybody know that this is just one of the best creators on this app when it comes to U.S. Supreme Court things. So if you don't understand what's going on in the Supreme Court and how it works and a lot of the different things going on, he's just an incredible creator. So highly recommend. Incredibly informative. So, and then also SCOTUS blog, because tomorrow, everyone, we are going to see oral arguments in the morning for the CASA case. Now, the CASA case is actually 3 cases put together. We have the state of Washington, CASA, and then New Jersey. And the state of Washington put a nationwide injunction. All right, so nation injunction into place. And this question that keeps coming up is, well, wait a minute, is that okay? Can you really do that? Let me get my map out here. Because here are different circuits set up here. And you can see, right, if we're over here in Washington and they put in a preliminary injunction, should it really be applicable to North Carolina? Is that okay? And this has been an ongoing question that hasn't been, in my opinion, from the cases I've read, it hasn't really been definitively set down. Like we've been hearing from the justices over just this session even, some back and forth over it. And last year we heard some discussions too. So we've got to kind of get it sorted out. And we have a pretty clear split between the justices on who wants what. So this is going to be the case to kind of set the precedent, in my humble opinion. So we need to keep an eye on that. Now we have, again, right, Skelikos on YouTube. Thank you so much, June Marie. I appreciate that so much. Let me make sure. I think I put too many L's in. Did I put too many L's in? Okay. Hold on. I'm writing it down. I'm going to put it on a sticky note so I don't ever forget. Again, Skelikos. My goodness gracious. On YouTube. Okay. Oh my goodness. I even had spelled it wrong. Yikes. Oh my gosh. I'm so thankful for the help, everybody. I'm so thankful. So, anyway, that's what's going on. That's the case for tomorrow. Now, the vehicle that they're using in order to make the decision is this set of cases. So Washington put that nationwide injunction on, and then we have 2 other places, again, 2 other jurisdictions. So this is a birthright citizenship case. Everybody remembers that, right? Where one of the first orders that he put into place. Here, let me grab my executive order sticky note here. That's very convenient, actually, having it up on the wall. This is the executive order here. Now, there is a federal code number you can find, but this is the name of the executive order regarding birthright citizenship. And he had done this the very first day he came into office. And with the birthright citizenship, it was this directive that, we're not going to have that anymore, which is odd because the Supreme Court has said no, and the 14th Amendment also. So there's that. And so the court in Washington was like, no. But until the cases actually get decided on their facts and these laws get hashed out, the state of Washington put an injunction in place saying you can't do anything right now. We have to pause everything, keep the status quo until we can resolve these issues in court. And now there's this question of, I'm not sure whether or not a nationwide injunction is appropriate. So we've got the issue of a universal injunctions improperly grant relief to non-parties, or what I would like to call, and I might get Gorsuch and Alito mixed up, because they're very similar, but I believe this is Gorsuch's take on it based off of a concurrence that he was a part of with Alito and Thomas last session. I'm trying to remember what the name of the case was. I think it was like something Poe. Well, anyway, that's neither here nor there. But this is one of the big issues. District court's injunctions improperly grant relief to the states. The next one, the district court's injunctions improperly prevent the executive branch from developing implementation guidance. So see here, this implementation guidance is fancy talk for executive order directive. And then talking about how the equities actually favor a stay. So this is what their arguments are going to be roughly about when they present tomorrow in front of the Supreme Court. Do you think the Supreme Court will uphold it still? No, I'm not sure. I'm not sure, in all honesty, because we had a pretty clear split, 5-4, on these kinds of questions before, but I just, I'm not sure. It really is going to be the Chief Judge and Justice Amy as well. So, and again, I'm not trying to be rude. I just struggle with the hyphenated last names. Now, I had a full chart here of the Supreme Court, and I think someone in my family, they kept commenting that when they got up in the morning and went to the kitchen, they could see the whole U.S. Supreme Court, and it really bothered them. So I think somebody took it and hid it, so they didn't have to see it. Let me just check one more spot and see if I can get it here, because I think it's helpful to see the justices when we're talking about the Supreme Court. But again, I'm not sure here if somebody took it. We'll see. Let me see. No, that's not it. That's not it. That's not it. No, that's not it either. I think I'll probably just have to print another one out. But I'll be asking everybody. We'll be doing an interrogation later to see who it was that took the Supreme Court picture. That happened with the mugshots too, for Trump's mugshots. I came out one day and they were gone. And somebody in my family, I won't say who, was like, I just can't look at it again. I can't do it. Oh my gosh, which cracked me up. And understandable, but here we go. I think I can get most of these still with my puppets here. All right, so we have Justice Kagan here, Justice Gorsuch, Justice Kavanaugh here, and then, let's see, Justice Jackson, Justice Connie Barrett there, and let's see, Justice Alito here, and I think the Chief Justice might be in another place because I've really been struggling with my thoughts about him recently, so he might be missing. Okay, how many do we have? Let's see. 1, 2, 3, 4, 5, 6. So we're missing Justice Sotomayor, Justice Thomas, and we're missing the Chief Justice. So I'll get those next time, all right? The reason I like to bring these out is because that it makes it easier to explain how I think the court's going to rule. Oh, there's Justice Sotomayor. All right, nice. Yeah. Oh, here's Justice Thomas. Oh, look at that. He was stuck to the bottom of this particular puppet. Fitting. And then I don't know where the Chief Judge is at this point. Nor does anyone else. So let me just I use the back of this one here, all right? And the reason why is I like to give a visual demonstration here, all right? We'll call this one the Chief Judge, all right? Oh my gosh, Chief Justice here. So this is how I like to set it out. Let me get this one sorted out. There you go, Justice Thomas. All right, so here we go. Here's the deal. We have 3 incredibly conservative, well, 2 really, let's start small. We have 2 extremely conservative justices, Thomas and Alito. They're also the ones that had articles of impeachment filed against them, although that's not made any movement, but there you have it. And then over here, so these 2, and then we have 3 extremely, I think they would call it extremely liberal justices here. I would not say Justice Kagan is extremely liberal. That is not how I would label her. She is definitely left-leaning, but several of her decisions have surprised me in how she has not gone down the liberal road. All right. So I don't know, but she's still here in the group. So we have two for sure's. Whatever's going to hurt somebody, that's what they're going to rule for. I'm so glad my ethics don't apply to the Supreme Court. All right, here we go. And then we have these three. Now, here's what happens. We have these three that were all nominated by the same president. Gorsuch, here, Coney Barrett, and then Kavanaugh. Now, Gorsuch came in instead of Obama's nominee was supposed to be in, right? Everybody remembers that? And then, Grassley and all of those people were like, man, we're just going to wait until the next election. So they waited. So the person who was supposed to have gone onto the bench didn't get his seat. So Gorsuch took his seat. So there you go. And then, of course, we all remember Kavanaugh and his love of alcoholic beverages. And maybe he could have made better choices regarding some things. Don't get me started, because I won't finish. I won't be able to stop. So we had those huge hearings, right? Where we had some significant problems with this one. And then Amy Coney Barrett, who is kind of like, right now, we don't really, she's changed a little bit. She's definitely, not changed, but she is definitely coming out in her decisions a lot different than what I think a lot of people would have decided. And then we have the Chief Justice, all right? And he doesn't have a picture because he's missing because I'm frustrated with him. So, and then here's the Chief Justice. Now, again, to show you, here's our three liberal judges, our two extremely conservative judges. So Justice Gorsuch is absolutely going to be in the conservative corner. Now, he will sometimes stray from that corner if we're talking about our indigenous peoples. Sometimes, although sometimes he doesn't. But for some reason, that's kind of his area where he's like, man, maybe I'll do the right thing. All right. Here's our three liberal justices here. All right. Now, Justice Kavanaugh, that leaves here, he is most likely going to vote conservatively. He and Alito have the same kind of stance when it comes to state versus federal power and presidential power. So usually he's going to vote conservatively. Now, the big swing vote here is always Justice Barrett. We don't know which way she's going to go. Chief Justice John Roberts, he may vote conservative or he may swing. So we have a one true swinger judge here. And then we have kind of like, depends on what's going on, swinger with the chief judge. These two used to be swingers, but now they're more conservative. And then these three, again, with our liberal justices. But again, sometimes Justice Kagan, there may be a case coming down the road, and it's like, wow, what did she just do? This Justice Sotomayor, of course, is our very most liberal justice, if you were to describe them liberal. And then I would say Justice Thomas is the most conservative, but I don't think it's really about ideologies. It's about harm to others. So, I guess he's the most conservative. Justice Alito, though, absolutely the most conservative and prejudiced. So these two probably are the most prejudiced. The chief judge is coming in third place for being prejudiced. I base that off of their literally what they say during oral arguments, everyone. The comments that get made, the dissent in Obergefell, that's what I'm basing my comments off of. I'm not just like, oh, well, they're conservative, so they're discriminatory. No. I'm talking about the actual language that they use here is, not great, all right? So when you say what's going to happen with nationwide injunctions, good question, because we have these three guys here who were like, oh, I don't know about all this injunction stuff, and it shouldn't apply to everybody. He's wishy-washy, so needs to sober up and pick a side. These three over here are like, no, we said what's good for one's good for all. Chief Judge here, again, wishy-washy, and then our swinger here. So we've got three potential swings, all right? So the reason why it's like, well, which way are they going to go? I don't know. We've got three solid against, three solid for, and then we've got three swingers. So I don't really know how it's going to go. So even if Kavanaugh decides to swing over here, then Justice Barrett could swing over here. And then that leaves, as many times is the case, the chief judge in the middle. Like, well, do I swing over here in order to get votes on another case that I want to have go through? Or do I swing over here in order to get, votes on another case that I want to go through? So he's basically playing the field. So the chief judge right now is just the mover and shaker of the whole situation. So hopefully that cleared it up. Hopefully that cleared it up a little bit for you. All right. Now, sometimes, don't get me wrong, sometimes Justice Barrett's over here. Sometimes she's like, no, that's, whatever. And, vouchers, blah, blah, blah. I mean, she's over here. She was a law professor at Notre Dame. And the other thing, too, is these two went to the same Catholic school. And these two, he was a student when she was a teacher at the Notre Dame. So, and then technically all of these here, if I get this, let me make sure I get this right. So we have 1, 2, 3, 4, 5, 6. Oh, that's not right. I guess Gorsuch. I guess I'll move him to the side. And then another way of doing it is 1, 2, 3, 4, 5, 6. Is that, and then these are the Catholics, and I'm not trying to say anything negative. Well, he's kind of Catholic. He's like I can't remember the name of it. I've just totally blanked on it. I keep trying to say Presbyterian, but that's not right. He's like the Catholic light religion. I can't remember the name of it. But anyway, the point is, look at all the Catholics here. Nothing wrong with being Catholic, but it's very unusual. No, not Lutheran. No. Oh no, no, it's like Catholic. Yes, no, Pentecostal. Is that right? Episcopalian. Oh my gosh, I can't remember. It's it's either Pentecostal or Episcopalian. I'm sorry. I don't know. I can't remember. Whatever it is you have to be in order to go to a Catholic school. In order to go to a Catholic school, it's like one of those. So it's like kind of Catholic. Like you can still sit at the lunch table. Oh my goodness. All right. So the point of that is, if you look at our population in the United States, thank you so much. No, I don't know. Episcopalian, are they Well, anyway, I digress. The point is, if you look at our population and you look at the number of justices who are Catholic versus our population, that's very unusual. It's very unusual. And I point that out again, not because they're using religion, but also because they're using religion. All right. So especially this one here, Alito likes to spit out that a lot. And then the Chief Justice, who's like, well, blah, blah, blah. And again, if you go in, you can listen to oral arguments. I recommend Oyez.org is one of my favorite places to go. You can, of course, go to the Supreme Court's website, but I like the Oyez.org. And you can pull up any SCOTUS case until like the 70s, maybe. I mean, I listened to Mapp v. Ohio, and that was in 61. So anyway, the point is, you can go to Oyez, and what's nice is that they'll play the oral arguments for the Supreme Court, and so you can hear different questions, and then they'll light up the judge that's talking. Because sometimes it's hard to figure out, especially right now, because I would have to say Justice Kagan and Justice Sotomayor sound very similar. Their voices sound very similar, so sometimes it's hard to distinguish. You can always figure out who Gorsuch is because he's the one with the biggest ego. Justice Barrett is like, this, we're getting to business. I'm going to ask questions, but we're going to be respectful and we're going to get to business. Justice Jackson speaks in like regular English. Alito, he's like completely full of himself and thinks he's the greatest gift on the planet, except for not as great as Gorsuch. Thomas, I think we can all identify Thomas. The chief judge is the one trying to keep the show running. And this one right here sounds like he may be thinking about something else at the time of the arguments. But that's my personal opinion on our justices, all right? Oh, my goodness gracious. This is a little extra here. It's a little extra when it comes to what that. So who knew that if you asked that question, I'd give you a 20-minute explanation. So there you have it. Who knows what's going to happen tomorrow? I really should find another Chief Justice picture, but I don't have it there yet. All right, so there you go. These are my puppets, and you may ask, well, why do I have puppets? And that's because sometimes when I'm listening to oral arguments and I'm doing a live, I put the puppet up so you know who's talking. Because they don't, there's no way to really know who's speaking unless you're used to their voices. So there you go. There you have it, everybody. That's my PB&J, Sloppy Joe, Supreme Court thoughts. All right. So how are they going to go again on this? We just don't know. We've got 3 and 3 and then 3 swingers. So it could go any way. Great presentation. Thanks, Duchess. Now, don't get me wrong. I don't just have puppets of the Supreme Court. Like, I've got this guy. I've got a puppet of this guy. I've got a puppet of this guy here. So, and these were on sticks. These were during the debates. Oh, I love the visual aids. So everybody was asking me to make puppets during the debates. And so, anyway, still useful. All right, let's get back to business here. This is a serious legal show. Oh, my goodness gracious. So this question was answering, how is the Supreme Court going to rule on the birthright citizenship case discussing preliminary injunctions? See, we got it back. We brought it all back around. Oh, my goodness. All right, so the other thing to remember, too, as this hits the media, is that this is the birthright citizenship case, but this is not defining or deciding whether or not the executive order was constitutional. That's not what the question is in front of the court. And one thing to always remember with the U.S. Supreme Court is they only will answer the questions that are asked. And they may even say, we're not going to answer one of those questions. So they're very specific. And when we're talking about this case, we're not going to be talking about whether or not it was okay or defining birthright citizenship. That's not on the table. We're going to be talking about preliminary injunctions, okay? Voodoo puppets. Oh, my goodness. I don't know. I tell you what, the voodoo stuff, like, that's serious. That takes like years of training. You can't just put a finger puppet together for that stuff, I mean, that's like, they're for serious. Oh, my goodness. All right, here we go. So that's what's going on in the Supreme Court tomorrow. Oh, my goodness gracious. All right. Yes, they certainly were. And they've been 9-0 on multiple cases, but then they've also not been. We just aren't sure which way they're going to go because we've got the swingers in there. Least favorite, I would say, truly, and I don't think I've made this a secret. I'm not a big fan of Thomas for ethics reasons and for his rulings, which I think are very lazy. And I think he does the bare minimum to sound posh and maybe get a couple, back slaps from his buddies. So I don't think he's incredibly professional. And then, of course, Alito, that I just absolutely disagree with his stance on things. But, he can still write a very scholarly opinion. I may disagree with it, but at least it's very scholarly, well organized, and so on. So those would be mine, too. I'm not a big fan of Roberts right now, hence why his picture's missing. I'm going to have to... Where did his picture go? I don't know. Where it went. No. Here we go. We'll have a Bernie palette cleanser. Hey, Bernie. Oh, my gosh. All right, everybody. Here we go. Oh, Justice Thomas, I think, is a bit lazy in his writing, or his clerk's writing. I think he's a bit a bit laid back. Yeah. So we've got the whole spectrum here, everyone. I'm not trying to pick on anybody. Yeah, Bernie palate cleanser. Oh, all right. So another piece too, and I'll be bringing this in tomorrow. I'll be coming back tomorrow after the arguments. One of the big cases where we can see how the justices have been falling on the injunction is the Department of State versus AIDS Vaccine Advocacy Coalition. This was just decided in March. So this is one of the most recent cases in here. And it has to do, again, with this idea of a stay versus, and whether or not a stay is appropriate during a temporary restraining order. So here you can see, oh, I guess Kavanaugh was in there. Well, whatever. I guess he's not as much of a swinger on this issue. But we have Alito, Thomas, Gorsuch, and Kavanaugh are all, doing that thing that they do with their conservative pieces of it. So I do have that one. I'll go through that tomorrow. And also, I thought this was interesting too. I printed the docket out for that case, for the AIDS case, because it's still going. This case that went up to the U.S. Supreme Court is still going. And this is one of the things I talked about last night or yesterday or whatever, is the appeal process in these cases. And let me just kind of give you a visual here. So we have the district court, which is where we have our trial. This is where we file our complaints saying an executive order is unconstitutional or withholding federal funds is unconstitutional. We take it to district court. And then you get like a verdict in here. You get a verdict or an order here, order, decision, whatever here. Who wins? And then you can appeal it to the Court of Appeals, right? So Court of Appeals here, we've got our circuit courts and federal courts here. So our different circuits, depending on where you're located. And somebody was asking, how did they make this determination? That's a great question. And you can go back to the Judiciary Act of 1898 and also kind of the updated view of it that was passed in, I think it was it 46 or 47? It was right after the war. I mean, the Second World War. But anyway, I think it was 45 actually. They kind of updated it around there. And so if you look into those different pieces that established the different locations, it'll kind of give you the history of it. Anyway, so we've got the Court of Appeals. And then if you don't like the answer, then it goes up to SCOTUS, right? So this is the federal court system here. All right. The state system's very similar, but it's, state law. So what has been happening in all of these cases against the administration is that if a judge makes a ruling that they don't like, for example, a restraining order or an injunction, then what they do is they go in and they do what we call an interlocutory appeal. Interlocutory appeal, which means we don't have a final decision and they're appealing it. So they appeal it to the Court of Appeals in order to get the decision, like, oh, should we have this injunction or not? Now, usually we'll start with a 3 panel for the Court of Appeals, and they'll come back and say yes or no. And then if the government doesn't like it, then they'll ask for an en banc, which means they want the full panel. So then they appeal it again. So you get 2 appeals inside of the Court of Appeals. All right? The 3 panel and the en banc. And then if you don't like that, then you can appeal it up to the U.S. Supreme Court. And then the Supreme Court makes a decision on this, preliminary injunction. All right? And then it goes all the way back down, chutes and ladders style, back to the original trial court. And then they continue forward on the case. A couple of weeks later, trial court sets out discovery schedule. And the government's like, well, we've got immunities and we don't want to give any information out. And the district court's like, well, you have to, because this is the law and this is discovery. So they appeal that, and it goes up on interlocutory appeal to the Court of Appeals. And they say, we shouldn't have to give you any discovery. And then the 3 panel says, yes, you do. And then they appeal it en banc. And then en banc says, yes, you do. And then they appeal it to the U.S. Supreme Court. And the U.S. Supreme Court says, you do. And then it comes all the way back down again. and then we go through discovery. And if we somehow get to the end of discovery, now we've got pretrial motions, right? So we're saying, no, motion in limines, these aren't going to work. This is going to work. And they're saying, well, your motion in limine is not okay. You're asking the government for too much. So they appeal the motion in limine up to the 3-panel court of appeals. And they say, no, the motion in limine is fine. And so then they appeal it en banc, and they say, well, that's fine. And then they appeal it all the way up to the U.S. Supreme Court, and it says that's fine. And then it comes all the way back down again. And then they try to assert a privilege as an affirmative defense. And then the court says you can't, it doesn't qualify. And then they appeal it. 3-panel, then they appeal it en banc, then they appeal it to the Supreme Court, and then it comes back down again. For 250 cases, this is the process here. And this is what happens when you have bad faith attorneys. All right, when you've got a batch of attorneys that are not ethically doing what they need to do. So if they're filing frivolous, they know it's going to fail, they still continue to file it anyway. You're not supposed to, but they do it anyway because they don't care if they get dinged on ethics. Because you can get an ethics violation, you can be sanctioned by a court, you can be sued for a terribly messy sexual harassment case and still become a district attorney for the feds in New Jersey. So like, why bother, right? So this is how we're seeing, this is, what I'm calling the T effect of what's happening in our system. This isn't normal. This isn't ethical. It's not okay. But this is what they're doing. Yeah. Yeah. So there's that. So that happened. So if you're wondering like, where are the accountability? Like, great question. We're all waiting for it too, because this isn't right. And they're doing it on every case. All right. So I had printed out the docket, and sometime I will take everybody through this to just show. This went all the way up to the U.S. Supreme Court and then came all the way back down. And then now this, again, the U.S. Supreme Court's decision right here came down March 5th. All right, so the Supreme Court ruled on it on March 5th, and it went back to the district court. They just filed in the first week in April another interlocutory appeal. So they have interlocutory appeal number 2 now on the books. So basically a month up and a month down in order to continue to get it going. Not even in discovery yet. We're not even at that phase. We haven't even started the process of the actual pre-trial things. What we have right now is just a situation where attorneys are, running the system up and back down rather than a good faith involved here. So keep that in mind. Well, I think the thing will be when SCOTUS has had enough, when SCOTUS finally comes in and says, we're tired of dealing with your petty questions on whether or not 2 periods are allowed in an interrogatory number 12, or if they will just start denying those appeals. We'll see. But then I want everyone to remember this too. Remember, we just had, who was it? Noam, like the puppy unaliver, who was like, oh, habeas corpus, yay. And then we also had, I think Bannon was like, habeas corpus, yay. And so they're talking about, well, if the courts don't do what we want, then we're going to invoke, we're going to go forward on habeas corpus. Well, let me tell you something. When you're in this cycle for 250 cases over and over and over again, at what point are you determining the courts aren't doing what you want? You know what I mean? Because if you're appealing each and every single tiny little thing in your case, then the court's like, yes, you can use it. No, you can't. Yes, you can. But you're not getting to any decisions. You're not getting to the trial. And I don't even know if we'll get to a trial, in all honesty, on these cases before the time's up on the 4 years. So I know a lot of people are worried about the habeas situation, but I would remind you, they're saying, well, the courts don't do, what they're supposed to do. Like, well, at what point? Is it the district courts? Is it the 3-panel? Is it en banc? Is it the Supreme Court? Is it all of the courts of appeals? Or is it just California and New York Court of Appeals? What about Texas? They're all right. So again, this idea of leaving it up to if the judges don't do what they want them to do is horrific. And then the practical piece of it is almost an impossibility. So there you go. That's our positive news for the night. On that note, so there you go. I'm not trying to be a bummer, just trying to kind of clarify that. A lot of people were asking me about that. So here we go. One more thing. Again, Abrego Garcia, a lot of people were asking me for updates. I did a full update on the Abrego Garcia case last night on the Tube. So if you look under the live tab on the Tube, which is the same name, I do go through the most current motion filed by Abrego Garcia's team, if you're interested. All right. And then, so then the last two bits here. So who has heard about the judge that was indicted by a grand jury in Wisconsin? Anyone? Anyone heard about that? I'm like, chat, have you heard about the indictment? Because this is some crazy business going on here. Yes, crazy, crazy business. So, oh my gosh, everybody, I tell you what, I have done a lot of criminal law cases, and I've been involved in a lot of indictments. This is crazy. We're on the crazy train right now. Okay. We have two counts, count 1 and count 2, in a 2-page indictment here, for which we have testimony. We kind of went through this in the complaint, where the person was testifying and just basically it's all hearsay. It's all like blah, 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 which is allowable for an indictment in front of a grand jury. But, the actual going forward and putting evidence forth, that kind of stuff for a trial, they're a long way from that beyond a reasonable doubt. But an indictment, again, is based off of probable cause, right? That's all you need. And a grand jury finding probable cause means that they found enough evidence to believe that this person may have committed the offenses they're being charged with. Now, probable cause is a level of proof that's needed. I won't spend too much time on this one. I try to give everyone a little explanation of the different levels of burdens of proof that are needed, but I won't spend too much time here. So when we're in criminal court, we need beyond a reasonable doubt in order to convict. Let's spell that correctly. Beyond a reasonable doubt, right? And then we need reasonable suspicion to believe criminal activity is afoot. That is our lowest level here. And then probable cause is in the middle. And this is where we have our indictments and our warrants, all right? No warrant can issue except for on probable cause, and that's in the Constitution. So probable cause is in the middle. So somewhere more than reasonable suspicion, which means, you can do a quick pat, and then beyond a reasonable doubt, which is a huge standard that has to be proven by the government. And a big pile of ham and bologna sandwiches. Exactly right, VC. Exactly right. And who knows? I mean, maybe once some evidence starts coming out and we start seeing what's in play here, maybe we'll go forward and a jury will convict. It's possible. But I will say this, it's pretty thin. It's thin. And it was thin when I read through the complaint. It's still thin now. So here we go. Count 1. On or about April 18th in the state and Eastern District of Wisconsin, Hannah Dugan knowingly concealed this person, a person whose arrest, a warrant in process had been issued under the provisions of a law of the United States so as to prevent the discovery and arrest of that person. After notice and knowledge of the fact that a warrant in process had been issued for the apprehension of that person. Yes, extremely thin. Violation of Title 18, U.S. Code Section 1071. And then we have count 2. So we've got grand jury charges here for count 1. And then grand jury charges for count 2. Now, we don't know if this was presented with other counts. That's a good question, too. I can't remember how many counts she had on the complaint. I feel like it was more than 2. I feel like there were at least 3. So they may have not gone forward on any other counts. Just two. Yeah, I mean, I see two here, but for the counts that, weren't appropriate, we're not going to really see how they decided on those. So here we go. Did corruptly endeavor to influence, obstruct, or impede the due and proper administration of the law under which a pending proceeding was being had before a department and agency of the United States, namely the administration arrest of this person for purposes of removal proceedings conducted by the U.S. Department of Homeland Security by committing affirmative acts to assist that person to evade arrest, including, and then this is what they're saying they included here. Okay, just two. Okay. It's possible to sue, but they're pretty protected. If they're making a good faith, if they're setting out in good faith that they believe that there's a violation of law, then, that's their job. That's what they're doing. So, they're kind of covered by immunity in that situation because they're like, look, we're just doing our job here. We just don't have enough information to continue to go forward. Not a proper arrest warrant signed by a judge. Right, and there is a difference between an administrative warrant versus a criminal warrant. But also, administrative warrants can be utilized. On the first charge doesn't fit. Right. All right, so let's take a look here. So what did she do? Confronting members of the U.S. Immigration, task force, falsely telling them they needed a judicial warrant to effectuate the arrest. And again, this is, a judicial warrant is signed by a judge. An administrative warrant for violations of, immigration stuff is signed by immigration agent. So, the ICE people just sign their name to it. Upon learning that they had an administrative warrant for this person's arrest, directing all identified members of the task force to leave the location of the planned arrest, a public hallway outside the courtroom, and go to the chief judge's office. So when she asked them to go, they're saying that was hindering, because she's like, why don't you talk to my boss? And then they left the hallway. So they're saying that was part of it too. Addressing that person's county circuit court criminal case off the record while ICE members were in the chief judge's office. That's a good question. I don't know that this is the correct code section, but if there's all kinds of discussions that go off the record. You can have discussions in chambers and hallways, wherever. The key, though, if you're doing things off the record, is that you still need to have both parties present. So I think that might be a bit of a hiccup for this situation. Directing the person and his counsel to exit the courtroom through a non-public jury door. Again, that happens all the time. I don't see any problems with that. Advising that person's counsel that person could appear by Zoom for his next court date. Which, again, I don't see how that would fall into line with what they're claiming here. She's just saying like, well, they're going to get arrested, so you don't have to show up in person. So this one I think is going to be the only one that, as an attorney, that I look at and immediately I'm like, what's going on here with this? But the rest of these, I don't know about that. It's thin. It's pretty thin. Yeah, the judge in Wisconsin. Yep. So the indictment came out again, but from a grand jury. So the protocols were followed here. We've got 2 counts. We'll just see what happens as time goes on. Oh, well, that's it. That's a good point, Jackie. Yeah, these are, I needed something extra sparkly tonight. All right, so that's that. So we've gone through this, and there is this, I should have, again, written down the name. There's another creator here that I just started following recently, and maybe I should do a post to link them because they're following this case pretty well, which is very interesting. All right, and then here's the last one, which I had been doing a teaser for earlier, which are last night, apparently, articles of impeachment went out onto the floor, right? Did anybody else catch that? I'm not sure if she's on administrative leave. She might be. Pen link. Now this is from Etsy. So, oh my gosh, everybody. This creator on Etsy is just like, what? Crazy town. So this is an Etsy shop again. And here's another one that I got too. I'm so excited. Oh, aren't they gorgeous? I'm just going to brag for a minute. She's suspended. All right. Well, and I'm not surprised. I mean, we got to kind of move them along. Okay, she's on leave or is she suspended? Right? So, oh, thank you. Thank you so much, everybody. Thank you. Hair thingies. No. Suspended. Yeah, I'm not sure. I'm not sure. I can see it going either way. For sure. So this is a hair thingy, by the way. Mine's tangled a little bit, in case you're wondering. Not the same as a pen. In an Etsy shop. Hold on here. Here we go. There we go. This is the Etsy shop. Maybe, hopefully I can put this in a place where everyone can see it here. Maggie Wand, is that right? Let me make sure my name, yeah, here we go. My name's not on there, so, and I love to get my pens off of Etsy. I get tons of pens from different creators off of Etsy, so huge fan. They do really amazing work. I know a lot of people have kind of forgotten about Etsy, but oh, I love it. I love it. Anyway, so there you go. That's our quick side note for that fun stuff. All right, so let's dive back in. We have articles of impeachment. Now, has anyone been watching the hearings that have been going on right now in Congress? That's some crazy business too, to keep our eye on. Temporarily suspended her. Okay, excellent. Ooh, pine cones, like the really cool ones that you can put in the fireplace and then they go shh like that. Oh, that's really cool. I think that's great. All right, well, that's good to know. And I'm not too surprised. I'm not too surprised that happened. All right, so here we go, everyone. House Resolution 353. Oh, I know the Noam hearings. Oh my gosh, Kaya. Oh my goodness. I tell you what. Oh my gosh, I really do appreciate when the Congress people actually take their time back. Like if she thinks that she's going to be able to talk over Congress people where their job is to like out talk each other, like, I don't know. She's got another thing coming. All right, so here we go. We've got, again, I just printed this out as the House Resolution 353 here. Really? Ben from Ben and Jerry? Oh my gosh, my goodness gracious. So impeaching Donald J. Trump, President of the United States, for high crimes and misdemeanors, which of course is what you need under the Constitution in order to impeach. Now, impeachment's mentioned multiple times in the Constitution. And Madison and Hamilton and John Jay, we always skip over John Jay. He did some good work. All right, he did some good work. But the two primaries in the Federalist Papers really wanted to emphasize there was a way basically to dethrone whoever was in charge of the executive branch. Oh, thank you so much. Oh, adorable. Thank you, Erin. I appreciate that. All right, so impeachment was important, and that was one of the biggest discussion pieces in the immunity case last year with, whether or not there was a privilege or if there was a full immunity, was this idea that, well, if we're going to hold somebody accountable in the executive branch, it should be through impeachment because that's what the intent was. All right, so this is important. And then it's turned into kind of a circus show. Really, taking credit for 3 more after ratification. I'm not surprised. Well, the whole administration, including the vice president. So good question. Anybody on the cabinet can be impeached. That's one of the things that a lot of people are talking about is if we're going to have articles out, why go straight for the president? Why not start with the puppy lady? So we've got Department of Agriculture, Commerce, Department of Defense, right? If he doesn't step down, he would definitely be a good candidate for impeachment. This is the wrestler lady, right? Department of Education, Department of Homeland. This one right here, the puppy harmer. There's something not right with this person if they're hurting puppies. So this one would have been an excellent choice for kind of like a test run for our impeachment process here. Department of Energy, Health and Human Services is going to be an interesting one. This may be also an issue because what happens is they try to leave and then put another person in place before you can impeach them. That's the thing. And then Interior, Department of Justice, she would be a good candidate too, actually. She's got I heard there's like some connections between, well, whatever. She would be a good candidate. Here, Department of Labor, Department of State. I don't know. That guy's got a lot of power here. Department of Transportation, the Treasury. I don't think this person knows what he's doing at all. Department of Veterans Affairs. So those are our bingo cards for the cabinet here. Any of these people can be impeached, and many have been saying this would have been a better choice as the first of a long series of impeachments that will be coming down without a doubt. Here. Really, they're going to impeach Mikey. Oh, that's a good point. I mean, he's a little different. And one of the biggest things that can really get your constituents upset with you is if you don't even show up. Like if you just show up, if you're just like there, you're going to get credit. But if you don't even go, like, yikes, that's a lot. Ours in charge impeachment is kind of I'm not sure. I think it's fair to debate it. I think it's fair to argue about it. I think the fact that this even made it out onto the floor to even, get this far, I think is saying something. I think it's good to, or sleep during a hearing, exactly. Or if you're meeting with someone who might be a really high level ranking person from the Middle East. I mean, whatever. You just have to show up. You get credit for that, right? This is a great first step, I think. I think somebody had to kind of do the first articles. So we had some discussion in the past about it, but these are the first really, and they're actually relatively well written, come to think of it. But articles of impeachment can be filed for anything that he's doing. So this is just our first run of it, all right? So our first go. And any of the department cabinet positions can also be put in there as well, although they're removable. So that's what's a little bit different here. So this one here again, we've got, I know Blondie. Oh, it's a problem. We've got this set out. And again, my prediction is this will be the presidency when we will see the closest that we'll ever get if we don't succeed in impeaching a president. I truly believe that. I don't know that the full 4 years will be able to be completed at this pace. It's just not sustainable. It's not sustainable in my opinion, legally, and mostly based off of my political science background. This is it. And I think we needed to. We've never had a full impeachment of a president before. So I think, we're setting that up. Here we go. Resolved. So this person, I have to be careful of the algorithm. President of the United States is impeached for high crimes and misdemeanors, which of course is not clearly specified in the Constitution. And that the following articles of impeachment be exhibited to the Senate. Article of impeachment exhibited by the House of Representatives of the United States of America in the name of itself and the people of the United States of America against this person, President of the United States, in maintenance and support of its impeachment against him for high crimes and misdemeanors. So here's Article 1. And I think it'll be really good to kind of go through what we've got here for the specifics. Because again, a whole nother set of articles of impeachment can be put into place. Oh, puzzle. I'm so glad they changed this puzzle. I'm so pleased with that. Thanks, TikTok. But another set of articles can be put in place for, the plane situation. That whole plane situation, yeah, that could be another set here. All right, here we go. Obstruction of justice, violations of due process, and a breach of the duty to faithfully execute laws. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that the president shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Further, Article 2 of the Constitution states that the president shall take care that the laws be faithfully executed. And that's the take care clause, right? The Fourth Amendment of the Constitution states that the right of the people against unreasonable searches and seizures shall not be violated. And we also have the warrants clause under the Fourth Amendment. And the Fifth Amendment of the Constitution states no person shall be deprived of life, liberty, or property without due process of law. So this is the federal due process piece, right? Everybody knows that the state due process requirements in the 14th Amendment, right? Grab my beverage of choice here for tonight. All right, so, and in violation of his constitutional oath to faithfully to execute the office of President of the United States and, to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed. So we've got 2 points here that I think are really interesting. For those of you that were with me as we went through the Georgia indictment for Mr. Trump, there was the RICO indictment, and it's still ongoing, so never you worry about that. It's still going. But one of the offenses, well, actually, I think it was 6. There were multiple people who were charged with violating their own oath of office. And it was very interesting how they had worked that into the RICO situation. So if you took an oath to, and you're in an elected position and you're violating that, under Georgia law, they had set out how that is a violation of law. Now here, I'm not sure, I don't know the federal code well enough to know if there is a federal code section for a violation of your oath. I would assume there is, but that would be one of the easiest hooks to hang your hat on when it comes to whether or not we actually have a crime. Because that's what it comes down to. Do we really have a crime or a misdemeanor? And if you can't check it off of a code section, it makes it more difficult to prove and go forward with it, right? Oh yeah, John, of course. It's for all of us. We're supposed to share it. Let's share it, right? But one sibling's gonna break it. Somebody's gonna mess it up. The rest of us won't get to use it. That's so funny. Oh, all right. So we have that, and then we also have this violation of duty. So kind of a, malfeasance situation. So he has abused the powers of the presidency in a manner offensive to and subversive of the Constitution in that. And then we'll get into some more details here. Using the power of his high office, he has engaged in this scheme or course of conduct through the following means. Number 1, by his orders and directions to subordinates, obstructed the administration of justice and embarked on a scheme to destroy and corrupt the legal system and the powers of the courts under Article 3 of the Constitution. Specifically, he's done the following. Whoa, that's like really, that's a lot. All right, that's a lot. Come on, hold on, let's go back a minute. Embarked on a scheme to destroy and corrupt the legal system and the powers of the courts. All right. I mean, that's a lot. That's a lot. That's funny. That's quite big, but let's take a look and see what they're backing it up with here. Directed and permitted his subordinates and attorneys at the Department of Justice to violate their oaths to uphold the Constitution, laws of the United States, and the rules of professional ethics by adducing misleading and willfully false representations to the courts of the United States and to otherwise abuse their official powers. Yeah, that's correct in my opinion. Specifically, he has 1, sought to dismiss without prejudice and under false pretenses the bribery and fraud charges against the New York City Mayor, Eric Adams, in an unethical quid pro quo exchange for the defendants. Well, I don't know about that. I don't have all the deets on Adams' situation. For the defendants' cooperation with the administration's political priorities, thus abusing the criminal laws and to unconstitutionally commandeer a state officer and unit of government in violation of the sovereignty thereof. That's serious. That's really serious, extremely serious charge here. So, extremely. Keep that in mind. Goodness gracious. Number 2, terminated and purged career Department of Justice attorneys without reasonable cause and in violation of the law in retaliation for their legitimate investigatory and prosecutorial work under prior administrations, including in relation to the January 6, 2021 attack on the U.S. Capitol and in retaliation for attorneys upholding their ethical and legal obligations, including candor and honesty to the courts. Yep, that's also a good point here. So this is going to be, let's do this in like salsa levels. All right, this is extremely hot. This one's more of a medium spice level. All right, that's what this one is here as we go through. Complete immunity of crimes while in office. Well, it's not complete though, Grace. It's not a complete immunity. Actually, if anything involves Congress, that's not immune. So if he has any congressional people involved, that the immunity doesn't apply. And then also if it's not an official duty, it doesn't apply. All right. So, just keep that in mind also. But that's something that's going to need to be argued out. And we're going down that road in the Blessing Game case, everyone. That's the civil case in D.C. brought against him for the January 6th harm. The civil case is still going, and they're still working on it because they're going to need to have hearings to go over what was an official duty and what wasn't because of the immunity case. So keep your eyes on that. All right, so here's B. Directed and permitted the evasion and defiance of binding court orders. Okay, that's extremely spicy. Again, we're just going to do it spicy levels, okay? Specifically, he has 1, removed persons from the United States to El Salvador, despite an order from the United States District Court for the District of Columbia, for which said court has found probable cause that the government committed acts of criminal contempt. Oh, I don't know. That's I would call this more of a mild, maybe it's a medium. We'll put it at a medium. Right. Oh my gosh, the calls, people. I know you're getting tired of it. I would say, here's my suggestion for the calls. Take like a 48-hour break. Take a 48-hour break, all right? Just go silent and then dive back in full force. I'm telling you, it works. You got to pull back a little bit so that they don't just start tuning you out and then dive back in. So that would be my recommendation. All right. Next, 2, removed Kilmar Armando Abrego Garcia from the United States to El Salvador, despite a binding withholding of removal order prohibiting the government from removing him to El Salvador. This is super spicy here. So, oh my gosh, this has got to be just absolutely, can you imagine? He is basically one of the pieces that he's being potentially impeached for is for putting this guy in El Salvador. Like, would that be enough of a hook for him to actually see what's going on and to see if that's really the road he wants to go down? I'm not sure. All right, so impeachment. Thank you, VC. I do not have the sticky note up, so here we go. Impeachment articles. And this is House Resolution 353. So 353. There we go. Right. So I'm just reading. This has been put out into Congress here. So this is, from Mr. Thandar here and multiple other people. All right. Here we go, back into it. Number 3, defied court orders upheld by unanimous ruling by the Supreme Court to facilitate the release. So this is the court order violation. That's pretty major. because that would be definitely, I'm not sure if it'd be a high crime, but it was definitely a misdemeanor violation here. Of Mr. Abrego Garcia related orders to provide information to the court and opposing counsel while publicly flaunting their refusal, right? Number 4, acted in contempt of court for violating a court-sanctioned settlement agreement. I'm not sure. This one's going to be, this one's definitely a mild. This is going to be a tough one to go forward on if we were proving this in criminal court, which we're not, but if we were, that'd be a mild level. 5, conducted and forced disappearances of persons without due process and without disclosing their fate and location to their families and legal counsel in violation of the Constitution and the rulings of the Supreme Court, as well as the foundational principles of due process and the rule of law. Now, this would be pretty major if he had not done the executive orders. So he set out this executive order, and his executive order, bologna sandwich, yes, but he can say he relied in good faith on the executive order to give him the power he needed in order to do this. So this one, I would say, that's going to be a tough one to prove. They're going to have pretty solid arguments against that one. C, directed and permitted the deliberate and systematic violation of laws duly enacted by Congress. Specifically, he has, 1, terminated inspector generals. That was huge. That was a huge thing. The officers responsible for detecting and preventing waste by auditing and investigating their respective agencies' operations and personnel in violation of the process stipulated by the Inspector General's Act of 1974, as subsequently amended. All right, now we're getting into the good stuff. These are the winning ones. All of the statutes that he's violated, like you can go through, and this is such an important point, everybody. There's a group, I think maybe six or seven inspector generals filed a lawsuit for being terminated without going through the proper procedure of explaining to Congress and then blah, blah, blah. He didn't go through the administrative procedure. So they sued, right? Now they may get through the court system, and the court may come back and say, well, whatever. But if legally he may not have an issue, but on the other hand, impeachment could grab him because of this. Like, you knew there were rules. You intentionally defied them. Is this at a level where, the courts are going to take over? Maybe, maybe not. But definitely congressional oversight was bypassed here. And that's an issue. So this is, I think, where a lot of the solid arguments are going to be, is that he's circumventing Congress. Because again, the House of Representatives is the one bringing the articles of impeachment, right? Not happy they got filed. Yeah, I think they're split about it, and understandable. Some people are saying, it's too soon, plan it out better. Other people are saying you should have picked somebody else from the cabinet. There's going to be a lot of different views on this. And too, with the Democrats, my view is going to be there's going to be some splits. I mean, we're already seeing there's some fighting amongst the Dems, right? And they can't seem to all get on the same page. And, people are that way. So we will have to see how this really goes down. Never too soon to remove a tyrant. True story. How much longer should we wait, though? That's a good point, Kaya. And again, how much damage, like how much of Rome is burned before you go in and say, stop burning Rome? That's a good question. All right, so this one's, in my legal opinion, very solid. Terminated a member of the Merit Systems Protection Board, a tribunal created to address widespread public concerns about the federal civil service. Yep, this one I think is credible too. Again, the government is winning in courts, right? So the court said put her back on the board. They appealed, and then the court said no, they don't have to be back on the board. You can dismiss somebody. But we had 2 years left on their contracts. Again, that was set out by Congress. So if Congress is like, dude, what are you doing? I think that's a valid argument for impeachment. Number 3, unlawfully transmitted sensitive personal information of private citizens and government employees in violation of, among other federal laws, the Privacy Act and the Administrative Procedure Act. So this is what I'm thinking. This is kind of some of those Doge cases, right, where that private information was released. There's like 12 lawsuits going right now. There's the student information, the Social Security information, the vets information. I think there's a couple more groups. Anyway, multiple groups of people's information was released. And so I think that, again, is another solid question for impeachment. Next, and also, again, that violation of the Administrative Procedure Act. And again, everyone, I have been saying, and I will stand by this, the Administrative Procedure Act and the administrative procedures are this administration's weakest link. This is what's going to get them tangled up, absolutely tangled up here. And the Supreme Court, especially with the Chevron doctrine that they kicked out in the Loper-Bright case, those kinds of things, they've already been dinking around with the APA. And so now they're coming in, and I think that APA is going to have like this big final battle when it comes to this administration. Oh, the librarian. Oh, I know. That's just, oh my gosh, I can't even think about that one. Out of all the cases, that one's like, oh my gosh, really? Are you kidding me? In all of this, he has willfully disregarded federal laws and the Constitution, imperiled a co-equal branch of government, and threatened the integrity of the democratic system. He thereby betrayed his trust as president, abused the powers of the presidency, acted in a manner grossly incompatible with self-governance and the rule of law, and has committed the high crimes and misdemeanors of obstruction of justice and affecting a wide-ranging scheme to destroy and corrupt the legal system and the powers of the courts under Article 3 of the Constitution. That's incredibly powerful here. That's super spicy. Yikes. I mean, that's pretty hardcore. What's the APA? The Administrative Procedure Act. Yep. So that was at the core of the Loper-Bright case, in case anyone was like, what do you mean the Chevron doctrine? So there was a case decided by the U.S. Supreme Court called the Loper-Bright case, in which they overturned the Chevron doctrine, right? And you might say, well, what's that? And I would say, if there was a law that was a bit ambiguous on a particular regulation or something, whatever, then the administrators could make the decision on which way it could go. They'd make, the experts in the department would make a decision rather than taking it to the courts. So if a law said, well, it needs to be sea green, and then everyone's like, well, what exactly sea green? And so it'd be like the person who's in charge of colors would decide, well, this is what we use for sea green, and this is what all the research says about sea green, so let's use this standard. But instead of being able to do that now, you have to go to court, and then the court determines what sea green is, all right? So that's what happened with the Chevron doctrine. Now, that's out of the Loper-Bright case, and a lot of this had to do, again, with this idea of what exactly the different departments do and what order and the power of the Administrative Procedure Act. All right, so that's the long and short of it. That's the Chevron doctrine in 30 seconds. All right, so here we go. Oh my gosh. Right, you betcha. All right, here we go, back up. So this is pretty major. This is pretty major when you're saying that, the president's trying to pull apart the justice system. Oh, thank you so much. Oh, lovely. All right, next. Wherefore, he, by such conduct, has demonstrated that he's unfit to govern a nation by and for the people, has acted in a manner grossly incompatible with self-governance, and the rule of law will remain a threat to the Constitution if allowed to remain in office. So, the language here is just really interesting. I've not seen prior impeachment pieces where it has actually been possible. Like this, of course, when they went through with, what was it? I can't remember who they tried to impeach, the Homeland Security person. I don't remember who it was, but they tried to impeach multiple times in the last president's administration. And the language was just like, are you serious? Like, who wrote this? But here it's like, well, that they could argue that. Will they win that argument? I don't know, but they could argue it. Oh, Mayorkas, thank you so much. Yes, exactly. Thank you so much. I apologize. I'm terrible with names. That's my bad. So, 7 through 12, what's that argument? So the argument, this isn't necessarily a full argument. They're just kind of wrapping it up. So by such conducts demonstrated he's unfit to govern a nation, right? So this is really their closing piece. Their arguments were set out earlier above this. So if you're specific on that, that's the closing statement basically for the charges earlier. So Article 2, usurpation of the appropriations power. So this is the other one that's really big that I'm curious about, because we have so many lawsuits right now. Frozen federal funds, deprivation of funds, canceling like humanities grants, science research, hospitals, like all of this stuff that Congress was like, here's the money you're going to get, and they're not getting the money. That's huge. That, in my opinion, is like truly the biggest constitutional crisis. Now, it's not as, huge or as heart-tugging as the Garcia case, of course. But if you look structurally at our government, at the Constitution, that is the biggest hit to the Constitution right now, is this idea that Congress has set the money out and the president is not allowing for it to go forward. So I'm interested to see what they have to argue here. So let's dive in. All right, Article 2. So the Constitution provides that the House of Representatives shall have the sole power of impeachment, that the president shall be removed from office on impeachment for and conviction of. So this is the House of Representatives, right? And then here's the Senate that convicts treason, bribery. I'm wondering about bribery with the plane now. Could we argue that for the plane? I don't know. Or other high crimes and misdemeanors. Further, Section 9 of Article 1 of the Constitution states that no money shall be drawn from the Treasury, but in consequence of appropriations made by law, right? And so everybody sees the problem with that, right? The problem with how this was set out. And I don't know. I'm not going to blame Hamilton, but I kind of want to. Because you see, the Department of Treasury is part of the executive cabinet, right? So this is where the money is, even though the Congress is the one that decides where the money goes. So you can see how we're having a problem here, because we've got executive orders saying all funds need to be paused. Meanwhile, Congress is like, you all need to have this money. So further, Section 9 here, no money shall be drawn from the Treasury, but in consequence of appropriations made by law. In his conduct of the office of President of the United States in violation of his constitutional oath to faithfully to execute the office of President of the United States and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed, he has abused the powers of the presidency in a manner offensive to and subversive of the Constitution in that. And then now we will get the support that they're using to back up their statement here. Okay, so number 1. I don't know. We're not listing numbers here. We'll see. Using the powers of his high office, he has unlawfully usurped Congress and its power to appropriate funds, thereby nullifying the appropriations clause in the Constitution and violating the Impoundment Control Act. Yes, we love to see that. We love to see this language here. Since taking office, he signed numerous executive orders directing agencies to withhold funds appropriated by Congress. The president does not have the power to override spending laws or impound appropriated funds. This is a key here. This word right here. That's what you want to grab onto with both hands and start running with it. That's what we're looking for. A principle affirmed by numerous Supreme Court rulings. he has withheld funds and terminated en masse federal employees in numerous federal agencies and departments, including the following. Now, this can kind of go either way because there's some question about the discretion of terminating certain people, but the sheer quantity and how he's gone about it, again, administratively, was done incorrectly. And those rules still, apply. Just because it's not a rule that he heard of or paid attention to doesn't mean it's not a rule that is actually full law. So here's number 1, directed the dismantling of the Department of Education as enacted in the Department of Education Organization Act, signed into law by President Jimmy Carter. The Department of Education was established by Congress to create reform in the education system throughout the country, distribute federal aids to students in places of learning, and prohibit discriminatory practices. The president does not have the authority to dismantle the Department of Education, and is signing of Executive Order 14242, which aims to improving education outcomes by empowering parents, states, and communities, violates the law of the Constitution. I think this is an excellent point, right? Because if you want to pull apart a department, there's actually a protocol you have to follow. Here, hold on a second. Let me see here. I've got, here we go. So on my wall of executive orders, here is the executive order that they're referring to here. So I'm just going to add this number real quick. A little housekeeping moment so I can add the number. Here we go. Back up on the executive order wall with that one. So again, you've really got to just follow your protocols. And if you don't, you're going to get called out on it. And Congress can call the president out on not following the proper protocol, especially when it's in a violation of congressional power. Right. It's all about the money, though, isn't it? So next, unlawfully directed the elimination of the United States Agency for Internal Development, USAID. Oh, this was so sad. This is still really sad. This is like life and unalive situation. Multiple lawsuits, again, filed here. As enacted by the Foreign Assistance Act of 1961, signed into law by President John F. Kennedy. USAID plays a crucial role in delivering foreign assistance worldwide, including disaster relief, conflict relief, combating global diseases, promoting educational programs, and enhancing food security in developing countries. By dismantling USAID and freezing foreign assistance, he has severed the United States from its humanitarian role as directed by Congress. That's an interesting point, leaving other countries and potentially our adversaries to fill in the role the United States has abandoned. That's true. Again, I think the better argument for this is that he didn't have the authority to dismantle it, because we actually have a law that talks about how to dismantle something, and he was not in compliance with that. Again, probably a dozen lawsuits over this. Well, maybe not that many. Let me look here at my chart. About 8. I think we've got 8 USAID lawsuits against the administration moving forward. And then number 3 here. Doesn't care what law or what part of the Constitution. Well, I don't think I don't think he's linking the things together. I don't think in his mind, this is just my guess, he's thinking like, okay, I want to get rid of this because this group of people told me to, #Heritage Foundation. I don't even know what this group does, where they go or whatever, but somebody told me to get rid of it. And so I'm just going to write how to get rid of it, but I don't know what to say. So Stephen Miller's going to come in and write it down, and then I'm going to sign it, and then it's going to be gone, and then the Heritage Foundation will be happy with me. So that's kind of what's going on here, rather than saying, oh, there's actually a way to wind down an agency and decommission an agency. Let's follow those rules. I don't think that's really in his analysis. In my humble opinion, personal humble opinion. Number 3, created the so-called Department of Government Efficiency, DOGE, which has imposed payments, holds, and rescinded funds after disbursement. So that's another really big whoop-de-doo. Has utilized DOJ to unlawfully block or impound appropriated funds to dozens of federal agencies, including the National Institutes of Health, the Federal Aviation Administration, and the Department of Veterans Affairs by impounding congressionally appropriated funds. He and DOJ have not only violated the law, but have negatively impacted the American people by cutting jobs, halting critical services, and rescinding grants for programs in defiance of the express constitutionally binding will of Congress. So again, this is another huge point. They're right. They're absolutely right. So to actually prove this in the Senate, they would have information in order to do that. Now, whether or not the Senate turns into a jury nullification situation, that's to be determined. Using the powers of his high office, he has unlawfully withheld congressionally appropriated funds and attempted to dismantle congressionally mandated agencies. By withholding funds and crippling agencies, he's prevented the federal government from performing critical duties here and abroad. That's another huge piece as well. So when we look at the two cases, and I think it's Harris and oh my gosh. Okay, I can't remember, but there's just too many cases going on. We have the National Labor Relations Board person who was fired, and then Harris. So I can't remember the name. Two distinct boards. The problem is by terminating them before their time's up, they took the number of people that they needed in order to vote on stuff away. So these committees or these boards that review if there are harms being done don't have enough people on them. So you see how they've crippled that system. And that's kind of a big deal when you're dealing with the National Labor Relations stuff and the other board. I can't remember. I can remember one name and one board. But anyway, the point is, they've cut the ability of the federal government to do its job by removing these two people. So that's something else to kind of keep in mind as we go through this. That's exactly what's happened, is that they are removing the ability to do their job. He's threatened the well-being of the United States citizens through the gross misconduct of his office, resulting in dire and life-threatening consequences on the world's most vulnerable populations. And that's true. That's, something else. And the case I was talking about earlier, the AIDS case that's been up to the Supreme Court and back down, and then we'll probably go back up again. People just, I don't think, realize how much is done out in the world when it comes to diseases and various things like that for vulnerable populations. And it's in this country's best interest to go down that road for, our own people as well. So that's definitely a hiccup here. Oh, it is. Oh, it absolutely is. And children, come on. But I say this, but then I pause for a moment and I say, remember today's hearing where, the puppy unaliver is like, we can do whatever we want with habeas corpus. Like, is she going to care that there are children in other countries that are being harmed? That empathy isn't there. And she's in such a powerful role that it's just, it takes your breath away for a minute when you think about that it's just not, it's not a priority to her, as you can see from her prior behavior. All right, here we go. Wherefore, by such conduct has demonstrated he's unfit to govern a nation by and for the people, has acted in a manner grossly incompatible with self-governance and the rule of law, and will remain a threat to the Constitution if allowed to remain in office. So again, this is just, basically echoing the prior closing paragraph. All right, somebody had asked me about that earlier, so just kind of closing that up. Yeah, the empathy. I mean, are you kidding me? Are you kidding me? Puppies. Oh my gosh. It's just, it's a lot. All right. Article 3, abuse of trade powers and international aggression. Ooh, this one should be good. Here we go. The Constitution provides that the House of Representatives shall have the sole power of impeachment, right? and the president can be removed for impeachment and conviction of treason, bribery, or high crimes misdemeanors. So, further, Section 8 of Article 1 of the Constitution states Congress will have the power to lay and collect taxes, duties, imposts, and excises, but all duties, imposts, and excises shall be uniform throughout the United States. In his conduct of the office of President of the United States and in violation of his constitutional oath to faithfully to execute the office of President of the United States and to the best of his ability preserve, protect, and defend the Constitution of the United States and in violation of his constitutional duty to take care that the laws be faithfully executed. He has abused the powers of the presidency in a manner offensive to and subversive of the Constitution in that. So then we'll start walking through this issue. Using the powers of his high office, he has abused trade powers by imposing unjustifiable and unreasonable tariffs on foreign nations. Yes, causing a decline in the United States economy and the economies of countries around the world, and declaring the false existence of a national security emergency. This is also another issue. He's declared, I think, 5 different national emergencies, and they're all like questionable. They're like, I'm not sure actually the elements of emergencies have been met for those declarations of emergencies to justify his actions. So the tariffs contradicted trade agreements established by his administration and other administrations, including the duly ratified and binding treaty obligations of the United States, thereby breaking international laws and norms, leading to countries around the world to enact damaging tariffs on goods and services originating from the United States. His, quote, Liberation Day scheme, which imposed 10% tariffs on all countries, as well as additional tariffs based on a formula for reciprocity, widely mocked as nonsensical, led to the most significant drop in the financial markets since the 2020 crash triggered by the COVID pandemic. Ooh, goodness. Additionally, he has threatened foreign nations with invasion, the annexation of territory, and the occupation of sovereign territory through the use of military action. That's so true. Like, do we know what's happening with Greenland right now? Is Greenland okay? I'm just wondering. By doing this, he's implicated the United States and himself in violation of constitutionally binding treaty obligations, including the North Atlantic Treaty of 1949, the General Treaty for Renunciation of War as an Instrument of National Policy of 1928, and the Charter of the United Nations of 1945, and the American Treaty of Reciprocal Assistance of 1947, and has threatened the following. Also, I think too, well, I don't know. In the Abrego situation, we have the cat situation as well. That's not pulled out when they went through Abrego, but you could do it. You could add to it later. All right, here we go. So the annexation of the sovereign country of Canada. Oh my gosh. He has negatively impacted the deep and historic relationship between the United States and Canada by stating numerous times that Canada should become the 51st state under the threat of both economic coercion and military force. Yikes! Unlawful and aggressive military action within Mexico, to include drone strikes and the use of special operations military personnel. I hope my words here aren't triggering anything, but I'm just reading. Ostensibly against DRUG cartels in violation of the sovereignty and territorial integrity of that country and without any congressional authorization to use military force. Tea break. Oh, thank you very much. Sometimes I forget. I just get so excited about the impeachment. I'm going to have to, this may be our final, this may be my final section actually for tonight as I see the time. But yeah, we'll finish up here and then we'll do a closer. And, all right. So annexation of Greenland, that's what I'm talking about right here, Greenland, an autonomous territory in the Kingdom of Denmark. He has continued to use hostile language aimed at taking control of Greenland. I'm not sure hostile language is a crime, but I don't know. stating that the United States will go as far as we have to go to obtain control of Greenland. He has refused to rule out military action to gain control of the territory in violation of the international law. And despite Denmark's long-standing alliance and friendly relations with the United States, who goes after Denmark? I mean, come on. That's madness, right? Like, who goes after Denmark? What's happened? Oh my goodness. All right, number 4, annexation of the Panama Canal, owned and controlled by Panama. During a joint session speech to Congress, he stated that his administration will be reclaiming the Panama Canal. And he's refused to rule out military or economic action against the sovereign country. Number 5, I know, happiest country, right? I don't know, they use a lot of candles though. I worry about the environmental impact. I put that out there and I'll stand by that. Number 5, annexation of the Gaza Strip, involving the forced resettlement of the Palestinian population to the surrounding countries. He has stated that the United States will take over the Gaza Strip and own it. His proposal of taking over the Gaza Strip and the expulsion of its population violates international law, including the Convention on the Prevention and Punishment of Crime, of the G word here, would be unconstitutional absent the approval of the United States Congress, and is profoundly unserious in light of the grave humanitarian situation and ongoing armed conflict in Gaza. That's really a good point too, that it's so offensive, the way that it's so flippant. Using the powers of his high office, he has unlawfully conducted himself, bringing shame and embarrassment to the office of the presidency. That's a true story. People of the United States. He has betrayed the trust of the nation to conduct meaningful diplomatic negotiations as its chief diplomat, and failed to maintain peaceful economic and defense relations with foreign countries. This really is very well written, quite well written, actually. He has threatened the security of the United States through gross misconduct of his office, prompting hostilities towards Americans here and abroad, as well as foreign nations warning their citizens against visiting the United States, further harming the nation's economy. True. Wherefore, he, by such conduct, has demonstrated he's unfit to govern a nation by and for the people, has acted in a manner grossly incompatible with self-governance and the rule of law, and will remain a threat to the Constitution if allowed to remain in office. And then we have the next pieces here. So, and this is where I will have to pause on this. We're coming up on the second hour here. So, got to watch my vocal cords. But, so what are our thoughts so far? I think, it's really well written, very properly thought out. Let's go back to that first page here. Right. Whew. And again, high crimes and misdemeanors is the question at hand, and we'll see. I think some people are, of course, against it. Some people are for it, but my understanding is that it came last night. It was on the floor. I mean, it came out. It came out of the. How do I say this? Right. So it was allowed out onto the floor last night. Now, again, I would say anybody in the cabinet can be impeached. Personally, I think that puppy lady should be taken down, in my opinion, after what she said about habeas corpus today. Yes. This was pulled by the rep. This, you mean the resolution? Maybe, right. It's all true, right. Yeah, so none of this hasn't been passed. This isn't law. This is a proposed situation going on here. All right. So I'm not trying to say, this is passed. There's none of that. There's been no voting on this. There's been no going forward. This is this has been what's been proposed. All right. So just to clarify, hopefully, does that clarify things, VC? Right. So we have that. They made him pull. Made him pull it. Well, all right. He may need to just rework it. I thought it was yesterday. I thought it was yesterday. Mm-hmm. Mm-hmm. It was just pulled. Just pulled now. Keep on hoping they'll be able to. It was just pulled now. Like I thought they were impeaching Mikey. It was yesterday. Okay. Thank you so much. He read it yesterday. They recessed. The vote was today and it was retracted. Okay. Okay, thank you so much. Thank you so much. I'm glad you gave me that heads up, VC. Okay, 2 to 4 hours ago. Right. So I think though, I mean, even if it's pulled, just being able to go through this and see what they've put together, we can see what their intent is. And as I said before, anyone in the cabinet here, yes, they are on bingo cards. I thought we would have more people fired, honestly, everybody. I'm a little disappointed. But we'll see what happens. I thought they would have gone after the cabinet first. I was a bit surprised, but not disappointed. And here again, I think is a great insight into how Congress is feeling. Right. At the bottom to the top, exactly. Cowardice of the... Oh my gosh, VC, oh my gosh. Whoo, you are not wrong, my friend. Whoo, you're not wrong. Yikes. No one wants to replace them. Well, I mean, when you go for loyalty instead of merit, you're in kind of a different situation. I do have a Venmo, everybody. I do have a Venmo, and I think I call it my like sticky note toner fund. And there's a there's a link that you can go to if you're interested, and literally 100% goes to toner and sticky notes and paper. So if you're interested, thank you so much. Don't wait for bringing that up. That's so sweet. At this point, I'm going through toner like, whoo, nobody's business, and responsible recycling. All right, let's just put that out there. Okay, interesting. Well, no worries, everybody. No worries. You gotta put your own oxygen mask on before you help somebody else. So remember to always do that. But if several people have asked where they can send me Post-its, so that's what. There is a spot over there if you are interested in doing that. But with that, everyone, remember tomorrow will be the arguments for the preliminary injunction birthright citizenship case. We're not ruling on birthright citizenship or the executive order. We're ruling here. They're listening to arguments on preliminary injunctions and how far they can extend from one circuit to another. All right. So that's the big whoop-de-whoop for tomorrow. Also in the Garcia case, I'm keeping my eye on it. They've asked for a couple more depositions. At this point, they have not agreed, but as soon as any more information gets filed or comes through, I will let you know. The government, again, is just not doing anything to facilitate. So we've got no movement on that as that continues to go on. We had another person who was released from detention today in our group of First Amendment, or as I like to call it, people pulled off the street cases. Here, there was no, that person was just pulled off the street. Here's my daily case check again. And I do this because I saw Aaron's post, and I know a lot of people feel like there's so much, I can't keep track of it, and you're overwhelmed. These are the alien enemy cases, and I'm checking on them. Although these three here are the First Amendment cases, I'm checking on them every day to see what's happening. Where are they going? Where have they been? What's going on? So those are the first things I check in the morning, just to make sure I'm counting heads to make sure everybody's okay. So I will keep you posted. Again, we're at about 250 lawsuits, almost 150 executive orders, not quite to that 150 yet. So we are keeping an eye on that. Also, the Diddy trial is going on in New York, and my goodness, that's ugly. We have the Weinstein case also going on in New York as well. And then there's another case, I forget the name of it, but it's another huge, very disturbing case also involving yoga and happy endings that weren't happy. That case is just atrocious. That'll give you nightmares. That one's also going on. So I'll keep my eyes on it, everyone. But primarily I am focusing on the administration lawsuits. and the executive orders. So I'll let you know how things go and keep you posted. I'll be back again very soon. And hopefully Skelikos will be doing something on the arguments tomorrow. So we'll have to catch up with him. He does such a great breakdown of it. So take care, everybody. Yeah, and if it did get withdrawn, so be it. It was on the floor before, and it might have been, but I think it's really good to have some idea of where their head's at when it comes to the impeachment questions. So I will catch you all later. Have a great night.